Hello everyone, my name is Trina and I'm from the IP Office of Singapore, called IPOS for short. It is my pleasure to speak again at the Australian Digital Alliance Forum, and I would like to express my sincere thanks to Ben Vice for this kind invitation. In January 2019, IPOS and the Ministry of Law published our Copyright Review Report, which covers the consultations it held over 2016 to 2017 on a wide range of issues. In March 2019, I spoke at this very forum to give an overview of our recommendations for changes to our copyright regime. I'm pleased to tell you that early this year, we held our public consultation on the draft copyright bill. Not only does it implement the 2019 recommendations, it's also a complete rewrite and restructure of our current Copyright Act to streamline and future-proof our legislation. So for today's presentation, I will be covering the progress of the copyright review and talk about the key highlights of the new copyright bill and end up with telling you about the next steps ahead. This is the overview of the progress of our review so far. As mentioned, we held consultations in 2016 and 2017 and released a report in 2019. We held a consultation last year on the proposed framework for a new CMO licensing scheme. And early this year, we held the consultation on the draft copyright bill over 10 weeks, which just closed on 8th of April. So let me go straight into the highlights of the new bill, and I'll start off with general matters. Let me talk first about stylistic amendments. One of the guiding principles of the copyright review is that our regime should be clear and accessible so that creators, users, and intermediaries will understand how the law works to both protect and provide access to works. To achieve this, we drafted the provisions in plain English to ensure that the law is clear, readable, and easily understood whilst retaining a necessary degree of precision. You will see an example here. We have replaced phrases such as addition, which is stored on any medium by electronic means, in Section 7(2)(a) of the current Act with a simple electronic addition. Another stylistic amendment that we have made is to ensure that we use technology-neutral language. We want our bill, our copyright law, to be sufficiently broad to cater to modern technologies while continue to apply to emerging technologies. That way, we can accommodate new and varied ways in which content will be created, distributed, and accessed. So we have therefore adopted a principle-based formulation to provide this degree of flexibility. For example, in defining what is a flagrantly infringing online location, we have retained the definition that is an online location that has been or is being used to flagrantly commit or facilitate rights infringements. We have also introduced new provisions for commercial dealings in grey boxes to impose both civil and criminal liability. We use a non-exhaustive definition of device to include both physical devices and software, which could include mobile applications. The way we define device is, it includes a component of a device and a computer program. Another stylistic amendment that we have made is to introduce more illustrations for clarity. For instance, in the new exception for computational data analysis, we have included an illustration of what could be computational data analysis, such as the use of images to train a computer program to recognize images. Here are some of the substantive amendments that we have made in the copyright bill. We have updated terminology and concepts. For instance, we have decided to use simplified terms to describe materials in which copyright exists. Previously, we had a definition of works, which was literary, dramatic, artistic, and musical works, and then had another category called all subject matter other than works, which referred to sound recordings, published editions, and cinematograph films. We've abolished this distinction and have just used works, which means authorial works and all the various subject matter. We have also expanded the concept of publication to include the supply of electronic copies to the public over the internet. Now, one of the key distinguishing features of the new copyright bill is that we have made massive structural amendments. We wanted our bill to be streamlined and follows a thematic and intuitive structure. Under the current Copyright Act, you will see that works and other subject matter were dealt with separately. Authorial works were dealt with as a whole before dealing with subject matter other than works in a separate part of the statute but based on identical issues. This is the new structure of the Copyright Bill, where you will see that we collectively deal with works and issue by issue in contrast with the current Copyright Act. And we have also consolidated exceptions into a single part called permitted uses. We hope that this will make it easier to navigate rather complex copyright law. Let's go into the new rights that are introduced by the new bill. The first one is a change in default first owner of certain types of copyright works. Now, under our current Act, generally the author is a default copyright owner of works, except for employment in the cases of employment and commissioned photographs, sound recordings, and films. Of course, all default ownership positions are subject to contract. However, we felt that there was an inconsistency in this first ownership position. For instance, if you were a writer of an article under a commission arrangement, you would be the first owner of copyright unless a commissioning contract says otherwise. However, if you were a photographer, the commissioning party would be the first owner of copyright unless the contract says otherwise. Therefore, we have decided to introduce consistency in default ownership positions. Under the bill, creators have default ownerships in all works, all commissioned works, which includes photographs, portraits, engravings, sound recordings, and films. Works created by employees in the course of a contract of service, the default ownership vests with the employers. Insofar as this relates to authorial works, this is already the existing position. The bill extends this position to all other works, such as sound recordings and films. And of course, default ownership positions continue to be subject to contract. We've also amended the duration for unpublished works. Under the current Copyright Act, the duration of copyright depends on the work in issue and whether it has been published. So there is perpetual copyright for certain unpublished works. The changes that were made in line with our 2019 recommendations are there will be no more perpetual protection of copyright for any works. All authorial works, except anonymous and pseudonymous works, have the same duration of copyright, which is 70 years after death of the author, regardless of whether it has been published. Now, for anonymous and pseudonymous works, films and sound recordings, the duration of copyright depends on if and when the work is published or otherwise made public. If it has not been published at all, the duration of copyright would be 70 years from the making of the work. If the work was made available within a 50-year window period from the making of the work, then it would be 70 years from such publication. It would incentivize creators to publish their works as it would result in a longer copyright duration. We have also expanded sound recording rights. Let me explain this. Under the current Act, copyright in relation to a sound recording is the exclusive right to do all or any of the following acts: to make available to the public a sound recording or as part of a digital audio transmission. Under our bill, we have expanded sound recording rights in two respects. The first is that a new exclusive right of communication to the public replaces the existing restricted digital audio transmission right. Secondly, there is a new right of applicable remuneration for causing commercially published sound recordings to be heard in public. The amount is to be agreed by contract, or in default of an agreement, it will be decided by a copyright tribunal. This takes into account Singapore's various international obligations under the WIPO Performances and Phonograms Treaty, the US-Singapore Free Trade Agreement, and the EU-Singapore Free Trade Agreement. Another new right we have introduced is a right of attribution to authors and performers. This is a personal, non-assignable right for authors and performers to be identified whenever their works are used publicly. Now, this supplements the existing rights under our current Act, where authors and performers have a right against false identification. What is the scope of right? The author or the performer must be identified in circumstances where the work or the performance, as the case may be, is used publicly. These circumstances include, well, depending on the type of work used, publication of the work, supplying to the public copies of films or sound recordings, including the work, performing the work in public, communicating the work to the public, and exhibiting the work in public or artistic works. What is the manner of identification? The author or performer must be identified in the way he or she wishes to be identified, or in any other case by any reasonable form of identification. And this identification must be clear and reasonably prominent. And how it is reasonably prominent would depend on the work in question. What is the duration of such rights? Well, it is for as long as copyright subsists or a performance is protected. And what are the exceptions? Well, there is written consent to any act or omission. And there are certain exceptions for certain types of works. Example, computer programs or works made in the course of employment. There are also exceptions for certain uses of works that do not constitute copyright infringement. Example, the use of works for judicial proceedings. And there are, of course, further exceptions which may be prescribed by the minister in statute. And what are the remedies available? Now, while considerations of practicality and hardship on a defendant will generally not be relevant to liability, these will be taken into an account in an award of remedies where the court will consider factors such as knowledge by the defendant of such moral right, acts done by the defendant to mitigate the effects of the infringement, the cause or difficulty of identifying the author or performer, the cause or difficulty of reversing the infringing act, and as well industry practices. Another new right that we are introducing in the bill would be liability for commercial dealings in devices or services that facilitate access to flagrantly infringing online locations. We commonly refer to these devices as gray boxes, and they enable users to access infringing copies of works. So what is the nature of this right? It imposes both civil and criminal liability for commercial dealings in devices or services that facilitate access to flagrantly infringing online locations. What are the prohibited dealings? They include making the device, selling the device, or offering or exposing the device for sale, distributing the device for the purpose of trade, and offering to the public or providing the service for a fee. This is rather similar to what we call secondary infringement provisions for dealings in counterfeit products and infringing works. What are the types of prohibited devices or services under this new right, this new form of liability? Well, it must fall within one of the following limbs. You must have the device or service must have promoted, advertised, or marketed for the purpose of facilitating access to any flagrantly infringing online location. It only has a limited commercially significant purpose or use other than to facilitate such access, and the service or device is designed, made, or performed primarily for the purpose of facilitating such access. The rights holder who brings an action for infringement under these new provisions must show that the work is made available on a flagrantly infringing online location to which the device or service is capable of facilitating access to. And there is a certain element of knowledge. The infringer must know or ought reasonably to know that he or she is dealing in a device or service that falls within one of the above limbs. So those are the new rights introduced by the bill. Let me go into an overview on the new exceptions introduced by the bill. Now, one of the key provisions that we have in the bill is that exceptions operate independently unless otherwise provided. What this means is that If the infringing act does not fulfill the conditions of one exception, it doesn't mean that you may not be able to rely on another exception if those conditions can be fulfilled. And what is important as well is that exceptions cannot be modified or excluded by contract unless the below conditions are satisfied. The exception is a non-mandatory exception. The contract is individually negotiated, and the term purporting to modify or exclude the exception is fair and reasonable. Now, what is a non-mandatory exception? Well, all exceptions are non-mandatory except those listed in the Act itself. As you can see in the current Act, we have backup copies of computer programs, decompilation, observing, styling, and testing of computer programs. We have added on in the bill 3 more additional exceptions that cannot be excluded by contract. Exception for reproduction for judicial proceedings or professional advice, exceptions relating to galleries, libraries, archives, and museums, and exception for computational data analysis. The reasoning is pretty straightforward. We feel that these exceptions strike a balance between creators' rights and access, reasonable access to works for certain societal goods, and we do not want these exceptions to be undermined by contract. Now, for those that are not mandatory, the exception can be excluded by contract, but the contract must be individually negotiated. For instance, standard form contracts and website terms and conditions, or what we call click-through contracts, are not considered individually negotiated contracts. And even if the contract is individually negotiated, the term purporting to modify or exclude the exception must be fair and reasonable. And what are fair and reasonable are based on factors adapted from the guidelines for application of the reasonable test under the second schedule of the Unfair Contract Terms Act of Singapore. Now, we have also updated our general fair dealing provision. In 2004, we introduced a general fair dealing exception that was very similar to the US fair use exception. And we also had certain specific fair dealing exceptions, such as for criticism or review and reporting of current events or news. However, during the 2016 consultation, there was feedback that some felt that the general fair dealing exception was rather confusing, especially because of the fifth factor. The fifth factor was the possibility of obtaining the work within a reasonable time at an ordinary commercial price. We felt that based on the confusion in the market and by users and rights holders alike as to how this fifth factor applies, we decided to remove it as a mandatory statutory factor. Now, this does not mean that it cannot have any relevance in a case of this exception. It can still be considered by the courts where appropriate based on the facts of the case, but it is not a mandatory consideration. And that we decided to restate the general fair dealing exception as a fair use exception. This was what is called commonly by users and rights holders alike, and it brings it closer to the US provision whereby the courts could take a look at US jurisprudence. Now, all existing specific fair dealing exceptions are retained and restated under this broad fair use exception as purposes for which a work may be fairly used and subject to the fair use factors. The specific conditions for each fair dealing exception, like for criticism and review, is still retained, which is like, for example, the need for sufficient acknowledgement of the author. We have created a new exception for computational data analysis. What this is an exception allowing works to be used for the purpose of computational data analysis, which includes text and data mining, data analytics, and machine learning. What are the permitted acts? Well, reproduction of the work, which includes storage or retention of any copies made for the purpose of computational data analysis. Beyond reproduction, in very limited circumstances, copies of the work may be supplied to another person, and such supply will not amount to infringement. but the supply must be for either of the following purposes and no other purpose. There are only two that are listed in the bill: to verify the results of computational data analysis and collaborative research and study for the purpose of the computational data analysis. Otherwise, the works cannot be supplied to any person. If so, the exception will not apply. The exception is built around concepts of lawful access to and use of legitimate copies of a work. So these conditions must be present in order for the exception to apply. What do we mean by lawful access? The person who copies the work for the purpose of the computational data analysis must have lawful access to it. And the illustration that we have included in a bill is that X cannot gain access to the work by circumventing paywalls. And what about legitimate copies of the work? Well, X cannot use infringing copies of the work for such computational data analysis unless X does not know that the copy is an infringing copy. For instance, is obtained from a flagrantly infringing online location. X must not know this or have any reason to believe this. However, X can use the infringing copy if the computational data analysis is being used for, X needs to use the infringing copy for the purpose of which you're carrying out the computational data analysis, and you do not use it for any other purpose. For example, you may need to reproduce infringing copies for the purpose of research and study into copyright infringement. So these are the conditions that are present for the exception to apply. Another exception that I would like to briefly discuss is the exception for educational users at nonprofit schools. Now, in 2016, we suggested a broad purpose-based exception for use of materials for educational users, based on feedback from rights owners and intermediaries, as well as users as to when and why they would need access to such works. We have decided to limit the purpose-based exception to users of any online work or recording of a protected performance that is accessible without the need for payment at the time of access by non-profit schools. With the pandemic ongoing and the closure of schools happening intermittently and the move towards home-based learning, such an exception will facilitate and continue the work of our educational institutions. So as I said, it's limited to only online works or recordings of a protected performance that is freely available. And what are the permitted acts? Well, they are limited to reproducing, adapting, or communicating the work or performance in the course of an activity that has an educational purpose and carried out by or in connection with a not-for-profit educational institution. The user of the work must acknowledge the source of the online work or recording. Educational purpose includes collaborative research, giving or receiving instruction, acts to be prepared for giving or receiving instruction, and organizing or participating in an exhibition or competition, whether within an educational institution or at the national or international level. So that concludes the overview of the new exceptions introduced by the bill. And let's take a quick look at what are the other legislative amendments which were relating to the 2019 proposals. We also introduced exceptions for facilitating the work of galleries, libraries, archives, and museums. This will enable them to do works such as preservation of works as well as exhibitions, but for non-commercial users. Exceptions to facilitate use by print disabled users, exceptions for materials maintained by the government or its statutory boards for public inspection, and we had introduced a new class licensing scheme to regulate collective management organizations. For the class licensing scheme, what you have in the bill are empowering provisions for IPOS and MINLAW to establish the license conditions, which will be administered by IPOS. These are to ensure good corporate governance and transparency and good commercial industry practices by collective management organizations. IPOS will not be intervening in the tariff rates or setting tariff rates. Disputes over tariff rates between users and the CMOs are still to be adjudicated by the Copyright Tribunal. We envisage to introduce the draft license terms and conditions sometimes next year for consultation before rolling out the new scheme in the later half of next year. So what's the outlook for 2021 and beyond? Well, as I mentioned, we have concluded the consultation on the draft bill back in early April. We will now be consolidating and reviewing all the feedback and considering whether further legislative drafting refinements are needed to the bill before introducing the bill in Parliament in the third quarter of this year, with the new act coming to force in November 2021. And thereafter, as I just said, we will be looking at crafting the license terms and conditions for the new class licensing scheme for collective management organizations. So I hope this has given you a good overview of the progress Singapore has made so far in its copyright review, and we look forward to bringing the new bill to fruition by the end of this year, and perhaps myself or one of my teammates may be talking to you next year on the actual laws that have been passed. Thank you very much for your kind attention.